Welcome to the Law, Your Money, and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts.
And I'm Camille Barron, a financial coordinator also in Massachusetts. And Roberta, today we have a guest who's returning, I believe, for the third time because there's always something new in this field.
Yes, we are very fortunate, and I love her name. It's LoDolce, which means it's sweet, right?
That's right.
What a great name.
Thanks.
Anne LoDolce, welcome back. Except
Thank
now
you.
I know you're in South Boston.
Correct.
You've risen with the yuppies.
Correct. I'm there. But I still work in Brockton, and I have an office there, and I'm doing family law mediation there. And it's a wonderful field, and it's a great alternative to litigating divorces, where you go into the courts and you spend day after day before a judge who doesn't have the time or the resources to resolve your differences.
Yeah, so tell us what mediation is.
Well, mediation is a process where the parties who are separating or divorcing, or maybe a paternity situation, need some assistance to resolve their differences, so that when they appear in front of the judge, instead of having the judge decide what the destiny of the family is going to be, the parties decide. And depending on what the problem is, if it's a divorce, then there are certain things that the courts require that you include in your divorce agreement, and in mediation you resolve those typically about four or six things. In a paternity situation, it's relegated. The problem is relegated to child-related issues such as parenting plan, which used to be the old visitation issues, custody, and child support.
What are some of the other things that are required during mediation that have to be done before one goes to court?
Well, in mediation, first of all, in a divorce, the court requires that you resolve a series of items. If you have children, the first thing is custody. We're in a shared custody state, which means it is assumed or presumed that you'll start with shared legal custody of your children, meaning you'll jointly make the major religious, educational, and medical decisions together. Then you have physical custody, needs to be discussed and resolved, and then a parenting plan which sets out the times that the children are with each parent. And so that's the custody piece. Then there's...
Yeah, no, you're really excellent. But with physical custody, you said joint custody and physical custody. There's two different custodies there.
Correct. There's the legal custody, which is the decision making, which is the decision making is made by typically both parents together regarding all major religious, educational, and medical matters. Physical custody is a determination as to where the children will be living, principally, and if they go back and forth between the households, that might be a shared physical custody arrangement. But typically, we deal in mediation with resolving exactly where the children are going to be living and when they will be living in different places. And that's done in the parenting plan. So that's what the custodial designations are all about. And then the next piece is the child support, which is governed by federally mandated child support guidelines. But in Massachusetts, we have some flexibility. If you have a child that has some special needs or special talents, let's say your child is an athlete and maybe travels around with teams and has special equipment, then you have to figure out the cost of all of that and who's going to take the child. And all of that gets resolved in mediation and discussed between the parties. And if you went to court, the courts are really not equipped to deal with all of that kind of thing.
No, as mediator, do you suggest to them, well, you know, you ought to do this, and they go, well, we don't want to do that, and do you have to say, well, if you don't do that, this is what might happen? What happens
Well,
there?
I don't necessarily, I don't guide people affirmatively. I just tell them, first of all, see what they want to do and see what the differences are, because many times people are not as far apart as they might think. And if they come to an impasse, I might give them suggestions as to what other people have done or what the courts have done in these situations, and they talk about the different options. But they ultimately are the ones that decide. The mediator doesn't decide. The mediator is like a translator. If you went to Italy, you would hire a translator who tells you, you know, where to go and what to do, but because they're just interpreting what you're saying. And that's the same thing with a mediator. The mediator doesn't decide. The mediator guides and just gives them some parallels within which to work. I mean, for example, with child support, we have the child support guidelines, but there might be a reason to deviate from them if a child has special. Let's say a child has a horse, and you have to deal with the expense of the horse, and you can't have all of the child support allocated in one way. It might be diffused into other expenses as well. So the beauty of mediation is that you can adapt to your child's special circumstances.
Now, is this true? Would you happen to know as to like other states? Are most of the states like this, or as far as you know? Or?
We have for child support. The guidelines are federally mandated, so from state to state, all the states have to have guidelines of some kind.
Oh, that's good.
In California, for example, the guidelines are extremely complex, much more complex than ours. Ours are not easy to do, but they're not as complex as the child support in California. But they're different from state to state. But they have some formulas within each state.
Do people usually discuss the options when they're in the presence of the mediator? For instance, the example you just gave where somebody wanted to do one thing and someone else wanted to do another, and you said that you don't really make affirmative recommendations, but you try to translate. Do they usually then discuss it right there, or is it something they take away and then come back with?
Typically, they discuss their options right there. And some people choose to discuss them after the mediation as well, but depending on the problem in the marriage. I mean, after all, these people are getting a divorce, so you might want to have them, if they're going to discuss things, that they would discuss things at a McDonald's or some public place, so that the tempers don't get up there.
Do they usually have a lawyer?
I recommend that people have attorneys, and the cost of the mediation is still a lot less than if they litigated, because the role of the attorney is very limited. And but it's always a good idea to have 4 sets of eyes looking at a document, particularly the final document, than two sets of eyes.
Is it likely that the attorneys who have been hired by each party, would there be any disincentive for them to want to approach mediation rather than litigation?
Well, the cost of mediation, a mediated divorce, is substantially less than that of a litigated divorce. So you have a disincentive financially to the attorneys, but most attorneys are sympathetic to mediation. For one thing, we have a requirement in Massachusetts that before a case starts, that the attorney has to discuss mediation as an option with the parties, and the attorney has to certify to the court that that has been done. So it's all part of the process. And not every case can be litigated, and most cases get settled before they go to court anyway, but it's just a matter of how quickly it gets done and what the acrimony is. if you can mediate, you can contain some of that acrimony so that people don't get as mad at each other,
Yeah.
because it's a very emotional process to be dividing your property and your children and your house and everything else.
You have that saying, which I always remember: reconcile, don't rehash.
Resolve,
Reconcile.
but
Yeah,
don't
resolve.
rehash.
Yes.
Oh, resolve.
Resolve. That's
Yeah.
good.
Yeah.
That's
What a
very good.
great
Oh,
expression.
In comparison, say, to a litigated case, I assume that you have experienced litigated cases, right?
Correct. I litigated for 40 years
Okay.
before I dropped all my litigation cases.
Okay, so generally speaking,
Yeah.
every case is different, but generally speaking, are mediated cases less contentious?
They are definitely less contentious because, first of all, people that want to mediate, they have a framework, a method of thinking that embraces the option of getting through the divorce process with less hostility. And it's so much better for the family. It's so much better for the parties. I mean, the emotional content of sitting there with somebody and duking it out over every little thing is very, very painful. I mean, some people get cancer and they die and all, all kinds of things. I mean, this is a process that erodes your soul.
Oh, yeah.
And if you can somehow contain it a little bit and try and make some civility out of an uncivil process and retain some dignity, it's just so much better for people.
Do you still have the ones where the guys quit their jobs so they don't have to pay, so that the woman's hangs up or won't let him see him and then say he hasn't done? Do you still have those matters? Do they still have matters like that? They must.
Well, I mean,
how do they get rid of the hostility?
Yeah, if those kind of people with those kinds of attitudes typically are not embracing mediation. They want to they want to really get every pound of flesh out of their spouse, and that's not necessarily what we're looking for. But on the other hand, if you can talk to people and you have that opportunity to contain the situation, it's just so much better for everybody.
You know what? Like, I asked you to bring in financial statements because I don't think people realize that they have to file a financial statement. And you said this was a short one.
How many pages is the short one?
And the short one is double-sided, 4 pages. Oh, 3. 1, 2, 3, 4, 5,
So
6,
it'd be-
7. There's 7 pages for the short
So
one.
that's
I don't
15
know.
altogether, right?
Well,
is
well,
that
no, it's a total of
of
7. Yeah.
Yeah, so-
so
yeah.
they have to file this before they go in?
Yeah, all divorces, whether they're mediated or litigated, require a financial statement because there has to be full and fair disclosure of all your assets and income to your spouse. Because how do you know what to negotiate if you don't know what
Right.
there is in the first place?
Are these
So-
under oath?
Yes, they are. And we have
Oh,
a
the
short form
certified,
and a
yeah.
long form.
What does
And-
the long form
And the
have,
long
if
form
they-
is a little bit, it's a different type of a draft, and it asks things in a different way. But it's the difference in the two forms. Of the short form is for people that make incomes of under $75,000, and the long form is for folks that make more than $75,000 a year. So the details are a little bit different.
Like a tax return.
Well, yeah, like a tax return. But and not only are people required to exchange financial statements, which we have them do in mediation as well, but there is also a rule that requires that they exchange 3 years of tax returns, 3 years of retirement statements, 3 years of bank statements, and all the health insurance information. So the whole concept of getting a divorce is based on complete disclosure, because you can't, as you well know, you can't come to an agreement if you don't know what you're agreeing to. And so that's the basis of it.
Other than confirming their willingness to mediate, are there any other attributes of a case that would indicate to you that they might be candidates for mediation instead of litigation?
Well, if people want to have their lives resolved in a private setting, that is a good reason to do mediation. Because if you are going to resolve your differences in a courtroom, it's a public place. Anybody can be there. They have people that are waiting for all kinds of hearings, and they hear all your dirty laundry. I mean, not only about the conduct, which is not heavily considered in Massachusetts, but it's considered. But they hear about your finances, they hear about your private issues regarding your children.
Are all those statements in the file too? Can anybody go and look at your file?
Anybody can look at anybody else's file, but the financial statements are held separately. They are called impounded, and they are kept separately in a sealed envelope in the file. And so they are kept private. But the divorce agreement, for example, which usually runs around 30 pages long and is a blueprint for going forward in dealing with assets and finances and child-related matters, are all public record. So your neighbors can get into it, or if you, for instance, if you're going to sell your house, you don't want to have certain details in the divorce agreement that you're willing to sell your house for $600,000 and you have it on the market for $800,000, because the buyers can go into that divorce agreement and see all that. So you have to be very careful what you include in these documents, because they are public record.
Now, when they changed over the probate laws, you know, when somebody dies, the wills and everything, did they change over the divorce laws too? Recently? Like, when was the last change?
Well, the big change was in the alimony statute, which was put into effect in March of 2011.
Now, what's alimony as opposed to child support?
Alimony is typically a periodic payment from the spouse who makes more money than the other spouse, and that payment is taxable to the recipient and tax deductible to the payor. And furthermore, the alimony cannot terminate upon the happening of a child-related event, such as a child turning 18 or 21 or 23. Child support, on the other hand, is neither taxable nor is it tax deductible, and is paid from one spouse to the other spouse, who is the principal caretaker of the children. And if you have a shared custodial arrangement, what we do is the child support might be adjusted in some way to take into consideration the fact that the child or the children will be transporting between the two households, and two households are principal.
What was the change in the alimony?
The alimony statute created, first of all, term limits, and so that if a person is married a certain period of time, then the alimony would be in effect for a certain percentage of that time. In a short-term marriage, the alimony percentage is less, and then the longer the marriage, the longer the duration. First, and additionally, the alimony statute provided for a termination of alimony upon the retirement of a spouse. But it's complex, because there are certain deviations. If you have the recipient spouse is ill or something like that, then the court has power to make some changes.
Is there as much alimony granted today where women are working, and I mean, just turn on the news. Most of the news men are news women. The stocks, I mean, everything's women. I mean, even in the courts, the women judges, women clerks, women everything there. are they still giving the woman, or is it going the other way too, where the men are getting the alimony?
Well,
How do they-
alimony is gender neutral, first of all.
Really?
So there are women that pay men alimony, and there are men that pay women alimony. It depends on who is the primary earner, and who makes more money, and
Interesting.
what circumstances, and how long the marriage is.
So the women out there who are listening, if they make more money than their husband, watch out, right? They might end up paying the alimony.
Under certain circumstances, they could be paying alimony. But if you have child support, you typically, depending on how much money is involved, but the typical wage earner does not pay alimony and child support, because our child support guidelines are not insubstantial. I mean, they're pretty hefty, because the idea is that children in a divorced family should be able to live comfortably, as well as children in an intact family, so that the children are not fiscally punished. So that's the whole concept of child support guidelines.
Well, you can't keep two households. Well, you can't keep two households. What you used to keep one, if it's the money split up.
Yeah, I was just going to ask, actually, that reminded me. So if somebody lives, if a couple in a family has been living in a house, say, that's worth $750,000, and say the husband was the primary earner, so he moves out, the wife has the children, they're still young, would it be expected that the wife would find a less expensive place to live? Or was
Well,
it generally thought of that she would be able to continue living in the same place, the children would have the same activities and those sorts of things?
It depends on the circumstances. If let's say there are two houses, there's a summer house and a winter house, well, obviously, you can look at it from that perspective. It depends on the circumstances, but typically, if you only in a regular situation where you have one house and you might have a little bit of retirement, we have some debt and not a whole lot in the bank, then the house would be sold, and then you would go from there. It's not, in the old days it used to be that the wife stayed in the house with the children.
Yeah.
Now, first of all, custody is gender neutral, and fathers are
Interesting.
far more active than they used to be.
And how old are the children that they can stop paying? I mean, it used to be 21, then it went down to 18, but isn't it if they're still in college or want to go to school, don't they still have to pay?
Well, in Massachusetts, the termination of child support is one of 3 periods of time. 18 if a child is fully emancipated, which they never are, meaning that they're self-sufficient, they're earning money.
Emancipated means they're on their own.
Correct. But if they're still living with a parent and they're not even going to college and they're principally dependent upon that parent, then the child support will continue until 21. And if the child is still in college between 21 and 23, then child support will continue until age 23. At 23, the cutoff is
23?
final.
What is 26? Or is that health
That's the
insurance?
insurance. They can
That's-
stay on the parents' health
Oh.
insurance if they're up until age
Correct.
26.
Oh, fascinating. Well, we're almost out of time, believe it or not. What fascinating topic.
Now, I understand that you've written a book.
Yes, I have.
yeah,
I've written
it's
a
a
book.
good
It's a
good one.
client book.
I've read it.
It's Divorce with Dignity.
Wonderful.
And it's about divorce from a mediation perspective, and it sets out different options that people have and circumstances.
And you're not kidding, Roberta. You've got to be kidding. You're not kidding. This is a great book. I have read it. How would our viewers get that?
Well, when they call to make an appointment, we send them a copy.
Oh yeah,
Oh,
that's
good.
great.
That's what we do. We don't.
That's great. How they can write us, and we'll see if we can get them.
Happy to.
But this, I was fascinated with this financial statement, because I remember when they used to be one page. But do you have any, before we leave, I want to say, do you have any interesting things that have happened with your cases, or even in South Boston?
Well,
We used to call it Southie.
yeah, I mean, the mediation is not a process that you, like when you go into court and you hear all these horrible stories. Mediation is a much more private and intimate process that doesn't lend itself to the glamour, and it's just so much better for people.
Yeah, you never hear bad stories about mediation or mediators. They're always, people are always happy that they did. Always good stories.
And they people that come to an agreement that is incorporated into the judgment of divorce are more apt to follow that agreement. If the judge imposes an order, it is less apt to be followed. There are statistics out there on that. So that's another consideration for people.
Well, the mediation probably lessens or lightens the load of the court so they can move stuff along.
Absolutely
more.
correct. Absolutely correct.
That's with the conciliating too. The conciliator moves it along too, but they're appointed by the court.
What's the difference between a mediator and a conciliator?
A conciliator is someone that is appointed by the court to bring the divorce or the matter to resolution at the tail end. And by then, all of the exchange of all of the documents has been done, and the parties come in. I'm a trained conciliator. Roberta is a trained conciliator, and the parties come in with their attorneys. Typically, they're represented by counsel.
Like that too.
And the conciliator is affirmative in giving them direction, much more directed than mediation, and tries to urge the parties to settle the case. It's a very successful process.
I think it's a great service too.
It's an excellent way of doing it. But you can do mediation as a combination of conciliation too, if people want to bring their attorneys, and that's another aspect of it.
This is how You've Got to Be Kidding bag, and it's time.
We don't have time for You've Got to Be Kidding.
We just did a You've Got to Be Kidding.
You've Got to Be Kidding.
Did
we? We've got to be kidding.
No, but that's a wrap. That's what we call a wrap. This is wonderful. I want people to know, while you're wrapping them up, we just did an activity book called Police Are Our Friends, and we're working on cyberbullying against and financial literacy. Here's a picture of police. This was made just for the Sharon Police, and then on the back is a picture that the chief of police drew when he was 6 years old when he wanted to be a policeman.
Yes.
So Camille always winds up.
You know, it's really interesting. Even the third time that Anne has been here, there's always something new and different to talk about.
Because
The
people
law
are
is
always
ever
new.
evolving.
Yeah, and people are different too. It's all different.
Yeah. Well, we really thank you. This is a fascinating topic, and even though it's not a pleasant situation, it's refreshing to know that it can be done with dignity. It's very, very refreshing.
Yeah.
We thank you. We
You're
hope
welcome,
that you'll
and
come
thank
back
you for
again.
having me.
Yeah.
And to our viewers, we thank
fine.
you for watching, and we hope that you will continue to give us your feedback and your ideas, because we depend on you for what we do on this show. Because remember, this is your show. The law, your money, and you.
And you.